So welcome everyone. We have folks joining online and we have folks joining by telephone. My name is Barb Van Hoy. I'm a policy analyst with the City of Colorado Springs Community Development Division, and it's my pleasure to welcome you to another Renter Rights 101 workshop. These are produced gratefully in partnership with Colorado Legal Services, the Pikes Peak Library District, the Justice Center, and Colorado Housing Connects. We will hear from all of them tonight about some great legal resources, legal and housing resources available to residents in our community. And that will be followed by a very in-depth presentation about all of the legal rights and responsibilities for renters and landlords in the state of Colorado, Colorado Springs. Before we dive in, I would like to talk just a little bit about the presentation format tonight. Oops, slides are going a little too fast. Here we go. For virtual participation, this event is being recorded and we will post the video online. Hopefully this week, but we'll do our best. It'll be soon. We also will be able to share the slides for the presentation tonight, but in order to share them with you, we need your email address. So you can register if you have not already registered. You can join that email list by either registering with the Justice Center's Renter Rights 101 page, or by subscribing to the Community Development Division's newsletter. And we'll be posting those links in the chat in a moment. So there are also there's also a PDF guide put together by Colorado Legal Services called the Renter Rights Guide, and that's available on the city's webpage. We'll also be posting a link to that in the chat, and we will be sending that out afterwards. So throughout this presentation, if you're called in, we're going to have all the attendees muted just to keep down background noise, but there will be an option for you to ask questions, and we'll let you know at that time when you can unmute yourself to ask questions. And I also wanted to make sure you're aware that closed captions are available in several languages. So the slide that you're seeing shows the controls in the corner, in the bottom right-hand corner. If you click on the gear, click captions and subtitles, and then you'll have an opportunity to select some different languages that will create simultaneous subtitles. And then there's also a description of how to get to the Q&A box if you are watching this on Teams. So the last thing before we get started is it still feels a little bit impersonal when we're online trying to connect with each other. So we would love to know who is here. If you would be willing, please use the Q&A box to tell us who you are. Are you a renter? Are you a landlord? Are you an advocate? Maybe you're with an organization. Feel free to share why you're here if you have particular concerns. It'll be great just for everyone to get a little sense of who is here. So the City of Colorado Springs Community Development Division sponsors these events because we are charged with preserving affordable housing, preventing homelessness, and improving struggling neighborhoods in our role managing the city's HUD grant funds. We are also tasked with furthering fair housing. Providing practical resources for renters and landlords and others like this event helps us achieve these goals. Ensuring that renters and landlords know their rights and responsibilities helps prevent unjust evictions and helps to keep people housed, which is very much what we would like to do. So I am now pleased to introduce some of our presenting partners to talk a little bit about what they offer in the community. So first I'm going to introduce Britt Kwan. She is the executive director of the Justice Center of the Pikes Peak region. They're working to decrease the gap in access to justice and legal services, putting on a lot of great events, and we're really excited to have her here with us to talk about those resources. Welcome, Britt.
Thanks, Barb. Let me go ahead and share our website real quick. Give me just a second. Oops, sorry, Barb. This is giving me a little bit of trouble. Hang on one moment. Okay, are you able to see our website?
Yes, that was
perfect.
On the hold up slide. Sorry about that.
It's okay. I think it was my bad. So I'm Britt. I work with the Justice Center. We are a nonprofit promoting access to justice in the Pikes Peak region. We have a few resources that are landlord tenant law specific, so I wanted to just show you those tonight. One that is more specific is we have a videos page that have a lot of different educational videos on legal topics. One of those topics is landlord tenant law. So if you're interested in 5 to 20 minute educational videos on a variety of topics, these are available here. These are created by lawyers who work in our region and who are familiar with Colorado law. Some of them are even created by Clinton, who's doing the presentation later. So these are a great resource. The other thing I wanted to point out is if you need free legal advice, we do have a weekly opportunity for that called Call a Lawyer. This is every Wednesday night from 7 to 9 p.m. You just call into our line and you can get connected one-on-one to a lawyer. We do have a lot of questions around housing law and evictions and landlord-tenant issues, and we do have volunteers in that area every week who can speak to those questions. The last thing I'll show you is we have a tenant toolkit. A lot of these resources we've already touched on, but a few of the things you can find in here are the housing videos, forms and documents, information on upcoming renters' rights workshops, and then our housing ambassador program, which is for folks to get involved with sharing resources and starting the housing conversation with their peers before they're in crisis mode. So that is it on my end, Barb. I'll pass it back to you.
Great, thank you, Britt. Next, I would like to introduce Deb Hamilton. And Deb is the legal librarian, strategic services librarian at Pikes Peak Library District. And Deb oversees the law and the legal resources collection for the Pikes Peak Library District. And Deb, are you able to share your screen if you're gonna look through the website?
Yeah. So is it up now? Can you see it okay?
In just a minute, I need to click some buttons on my end, and I should be able to do that. There we go. And there's you and the website. Okay. Thank you, Deb. Take it away.
Yeah, no, great. Thanks, Barb. So hi, everyone. My name is Deb Hamilton. I work at Pikes Peak Library District. I'm the law librarian there. So our downtown library, we have a legal research collection. I do want to show you just a few resources, though, on our website that will also be useful for you that you can access from anywhere. So the main website address is ppld.org. You can just also Google for Pikes Peak Library. When you get on this page, you're going to want to click on the word research here. That'll take you to all our research guides. And then we have one set up just for law. So I'm going to scroll down and find it here in the middle column. Then once you're on that page, if you could scroll down a little bit, under featured resources, I have highlighted a number of the things that you're going to hear about this evening. So here's a link to the Justice Center website where you can learn about those free clinics and get into the rest of their website. Colorado Legal Services, where Clinton works, who's going to be giving our presentation here shortly. There's the link to their website and how to get a hold of them. In Clinton's presentation, he's going to talk a little bit about the Colorado Revised Statutes. So if you want to read those are right there as well. And then I'm going to scroll back up. There's another sub-guide here called Eviction Information and Resources. And if you go in there, Under housing resources and nonprofits, Katrina is here with us from Colorado Housing Connects. So there's their website. And then if you go under general information on evictions and landlord tenant law and scroll down, you will also find the information where the recording and the pamphlet and all of the stuff from tonight's presentation will be loaded up to on the city's website. So just in case you lose those links that we put in the chat, we got it all here on the library website for you to find later. There's also a lot of other good stuff on this eviction information page, as well as some of those COVID-19 programs to provide both landlords and tenants assistance. So that's a good place to get hooked up with that information. If you forget any of it, though, you can always find me here too on the website. So feel free to reach out with a call or email, and I'll do whatever I can to connect you with what you need. So, all right, I'm gonna stop sharing my screen.
Thank you so much, Deb. We really appreciate that. And next, I am going to share Colorado Housing Connects website and introduce Katrina Brown. Let's see.
You ready?
Katrina. So, okay, now we've got everything up. Katrina, thank you so much for being here. Katrina is a housing counselor with Colorado Housing Connects. I've been at the Community Development Division for a year now, and I keep learning about new amazing resources that Colorado Housing Connects provides. So we're excited to have Katrina here to talk about those. So take it away, Katrina.
Thanks, Barb. As she said, I'm Katrina Brown, and I work with Brothers Redevelopment on the Colorado Housing Connects line. On the line, we answer a multitude of renters' rights questions. We do tenant landlord questions. We help with housing discrimination. We just answer questions. Anything legal, we then refer over to Clinton because he knows everything, and and Colorado Legal Services. We also help home buyers become first-time home buyers. We teach a CHAFA sponsored class for first-time home buyers, and we take questions for people wanting to become first-time home buyers. We take questions for down payment assistance and other resources or questions that people need that want to become first-time home buyers. We also help homeowners stay in their house. We help them avoid foreclosure. We help with home repair, and we help homeowners who want to refinance their homes. And then also we help landlords with landlord and tenant questions, because sometimes landlords have the same issues that their tenants have. And they have questions that they want answered as well. So we take a multitude of calls and questions daily and try to help people in El Paso County get housed, stay housed, and answer questions that they may have that are causing them problems or discrimination. And that's kind of what we do over there. I'll give it back to Barb.
Hey, Barb, you're muted.
Thank you. I've just been chatting along here. Thank you so much, Katrina. I just wanted to thank you again for being here and remind everyone to keep that phone number for Colorado Housing Connects, and also remember that we'll be sharing that, and it will be in lots of the resources. So thank you so much, Katrina. So now we are going to turn it over to the now becoming famous Clinton Albert, who is a housing attorney with the Colorado Legal Services. And Clinton has served with Colorado Legal Services for 3 or more years. His caseload is made up solely of landlord-tenant matters, and he covers a broad range of legal issues within that area. He's been presenting the Renter Rights series, both for our group, as well as many others since 2018. And when he's not practicing law, you might find him outdoors hiking and climbing. And Clinton, let me get your slides up here. We really want to thank you for being here and for providing this. I want to remind all of our participants that we will both leave time for questions at the end, but you also are welcome along the way to ask questions. Put your questions in the chat. We have a couple of folks monitoring them, and as long as they're pertinent to what's being talked about, we'll make sure that Clinton knows there's questions, and then others we can save toward the end. So welcome, Clinton. Thanks for being here.
Thanks so much, Barb. Good evening, everybody. Thank you for taking the time to attend tonight's presentation. My name's Clinton Albert, and I'm an attorney with Colorado Legal Services. So I'll just jump right into the slides. We've got a lot to cover this evening. Make sure that, there we go. So just kind of a disclaimer up front here. This presentation is for informational purposes only. Housing issues require a thoughtful analysis of both the facts and the laws they would apply to your matter. Also, over the last year and a half, COVID protections have changed on a near monthly basis, and those as well require case-by-case analysis. If you are a low-income member of the community or a senior citizen and are facing a housing issue, you may contact Colorado Legal Services at the phone number or online at coloradolegalservices.org. We are accepting some walk-in applications at this time as well. So I just wanted to kind of start this evening off by reviewing what the tenant protections are at different levels of government in regards to COVID-19. Unfortunately, at the state level, Colorado's executive orders have all expired at this point. So currently, there are not any state level protections in place. As you can see, there have been a slew of past executive orders, and as indicated, we'll make these slides available. Each order, I've included a link to that prior order. And again, the last little bits of executive orders that ran up through the end of July. Now, even though these orders are now expired, they do still apply to any kind of notice or demand that you may have received during that time period. So if you're looking at something from earlier this year or from later in 2020, even though the order itself may not today be in effect, it would still apply to that notice to quit or that demand for compliance that you previously received. Currently, the main source of tenant protections in relation to the ongoing COVID-19 pandemic stems from the CDC's eviction moratorium. This has recently been somewhat amended from down from a nationwide moratorium to communities, essentially counties, that are currently experiencing a substantial or high level of community transmission of COVID-19. The moratorium is now in effect through October 3rd, 2021. And essentially what this stands for is that landlords, owners of residential property, or other persons shall not evict any covered person. All right. We'll get a little bit more into this. The moratorium is still in effect. There are legal challenges pending to the moratorium. Most notably, the Alabama Association of Realtors versus the Department of Health and Human Services case is currently, I believe they are filing motions at the Supreme Court level. The Court of Appeals has kept the moratorium in place, but the Supreme Court will be the final judge on whether or not the moratorium is able to last through October 3rd. So again, landlords, owners of residential property, or other persons shall not evict any covered person. So who is a covered person? What is a covered person? That's any tenant, lessee, or resident of a residential property who provides to their landlord, the owner of the property, or another person with a legal right to pursue eviction, a declaration under penalty of perjury. So that's kind of key there. The moratorium is not what's called self-executing. As a tenant, you do have to provide your landlord with a declaration under the penalty of perjury. And that declaration states the following: that you're using your best effort to obtain all available government assistance for rent or housing, that essentially you expect to earn no more than $99,000 in this calendar year, or last calendar year, you were not required to report any income, you received some type of public benefit, or you received a stimulus check pursuant to the CARES Act. You live in a U.S. county which is currently experiencing substantial or high rates of community transmission levels of COVID-19. You are unable to pay the full rent or make a full housing payment due to substantial loss of household income, loss of compensable hours of work or wages, a layoff, or extraordinary out-of-pocket medical expenses. That you as an individual are also using your best efforts to make timely partial payments that are as close to the full payment as your individual circumstances may permit, taking into consideration non-discretionary expenses. And lastly, that eviction would likely render you homeless or force you to move into and live in close quarters in a new congregate or shared living setting because you have no other available housing options. So that's a mouthful, and all of those are required for somebody to be a covered person under the eviction moratorium. Here's a copy of the declaration that I referred to. You can find this online at the CDC's website. And just in case, not to bury the lead here, but El Paso County is currently experiencing a high community transmission rate. So here in El Paso County, the eviction moratorium would be in effect. Does this moratorium prevent all evictions from taking place? And the short answer is no, it does not. Evictions can still proceed for engaging in criminal activity while on the premises, threatening the health or safety of other residents, damaging or posing an immediate and significant risk of damage to the property, violating any applicable building code, health ordinance, or similar regulation relating to health or safety, or violating any other contractual obligation other than the timely payment of rent or similar housing-related payment. So essentially, evictions can proceed for anything except non-payment of rent. It's important to keep in mind that the moratorium does not waive rent. So if you are receiving the benefit of the moratorium now, I would strongly recommend that you be applying for rental assistance through the ERAP program to try to get that past rent paid, as well as potentially even future rent as well. So because once that October 3rd date comes around, your landlord can serve you with a demand for payment for any and all rents that have not been paid during the moratorium. So the substantial and high rates of community transmission. The CDC does have a website on those community transmission rates where you can just plug your county and state in and see what level it is currently in. Now, the difference between the county versus nationwide difference comes into effect on, well, what happens if the community's transmission rate increases or decreases. So if it decreases, if a county's rate decreases from substantial or high to moderate or low, then 14 days later, the moratorium will not be in effect in that county. If, however, a county's transmission rate increases from moderate or low to substantial or high, the moratorium would go into effect in that county immediately. Now, moving on now, before I move on to some updates here on housing law, I'm going to check the chat for questions. And I know that there are a couple questions here, but as they are not related to the COVID-19 protections, I'm going to cover those at the end of this evening. So there are some new housing laws to discuss. These went into effect at the end of June and are currently in effect for all tenants and landlords. So first of all, the language on a summons is now edited. Also, if you were a tenant and you were facing an eviction, if you were filing an answer, you must also state whether you believe you were given proper notice of the landlord's reason for terminating your tenancy before you got your summons. Very importantly is the change with regards to the writ of restitution after judgment. Now, I know that this is somewhat out of order, but what a writ of restitution is the document which allows the sheriff department to come into your residence following an eviction and remove you and your property from the residence to turn possession back over to your landlord. Previously, a writ of restitution had issued 2 days after a judgment for possession, the legal term for eviction, and a sheriff's office could serve it that same day. However, now, once a writ of restitution is issued, the sheriff cannot execute that until 10 days after the entry of a judgment. So in effect, unless we're talking about a weekend or something here, which may extend that time period, a sheriff cannot execute a writ of restitution until 8 days after the writ, assuming that the writ was issued 2 days after the judgment. Again, now that's more of an eviction part of the new law. However, during your tenancy itself, there is a few new laws that are addressing the same issue, which is rent increases during your tenancy. So if you are a tenant and you are continuously living in a residence for a 12-month period, your landlord cannot raise your rent more than one time. And it doesn't matter if there's a written agreement for the tenancy. It doesn't matter what the length of the tenancy is, if it's month to month, 6 months, forever. And again, whether that tenancy is a fixed term, month to month, or indefinite term, landlords are not able to raise rent more than one time in any 12-month period. Now, if there is not a written agreement, so if this is an oral lease, then landlords can only increase the rent after providing a tenant with 60 days written notice. Also, landlords may not provide a tenant with a notice to quit to terminate the tenancy with the primary purpose there being to kind of circumnavigate the 60 days written notice. So a landlord cannot give a 21-day notice to quit just so they can increase the rent and not provide the 60-day notice of rent increase. Again, it's a similar statute regarding rent increases that it can only occur once in a 12-month period. This one does fall in around the Mobile Home Park Act.
Hey, Glenn.
Yes.
We had one question specifically about the CDC moratorium paperwork.
Oh, there it is.
Yeah, so is it ever too late?
It is too late once the sheriff has come and started to remove you from the property. All right. So if your landlord has already served you with that summons and complaint and you're going to court, you can file the CDC declaration at court. If you have gone through a trial and you have lost that trial and a writ of restitution has been issued, but the sheriff has not executed it yet, you can go file that CDC declaration into court as well, which would put the court on notice and your landlord on notice that there is a CDC declaration and that you are declaring yourself to be a covered person under the moratorium. So there's not really kind of a time cutoff, as you have to provide this to your landlord 7 days before any court proceeding. So if you are considering doing that, it is my opinion that it's not really too late until the sheriff's there removing you from the property. And providing the declaration to the sheriff, if they were to show up, would not trigger the protections of the moratorium, because the moratorium requires that you provide that declaration to your landlord, right? So if your landlord gets a copy of it at any time before that sheriff move out on a writ of restitution, then that is okay, in my opinion, by the terms of the moratorium.
Thank you.
Of course, that's it. Thank you for the question. That's a very good point to make. So moving on from the legislative changes and legislative updates, and just to preview, come October 1st, there will be more tenant rights as well, and we will be discussing those in greater detail at the fall renter rights presentation in a few months. So just some kind of basics to think about before you move into your new home. First of all, as you're applying for a new residence, keep in mind that Colorado has a prohibition on discrimination in housing based on the source of income. Essentially what this means is that landlords cannot say, I'm not renting to you based on your income, whether that's from a lawful profession or occupation, and income or rental payments derived from any government or private assistance grant or loan program. So landlords, with some exceptions, are no longer able to deny somebody a potential tenant, a rental property just because they plan on using a voucher to pay for their rent. That is no longer permitted by law. And again, there's a link to that new-ish law regarding banned income discrimination in Colorado. This is a contract. So your lease is a contract, your agreements with your landlord or your tenants are all contracts. So it is best practice to keep everything in writing. If you have a verbal conversation, it's best to follow up with an email just kind of reciting what the conversation was and your understanding of it, because this is, tenants, this is a contract with your landlord. Oral leases are valid in Colorado. They're more difficult to prove. They are presumed to be a month-to-month lease, and you cannot have a lifetime oral lease. So if somebody's telling you, hey, you can live here, you can live here as long as you want, have them put that in writing. All right, because as a lifetime oral lease, that's not really something that's valid. Additionally, if you're applying for new places, keep in mind that in regards to application fees, landlords are not able to charge an application fee unless they're using the entire amount to cover the costs in processing an application. Costs may be the actual expenses taken to process an application, or the average expense that a landlord has per applicant when it processes multiple applicants. So think of that kind of the distinction between applying for a single family residence or one unit in a building of 50 people with 50 units with multiple vacancies at the same time. Landlords are not able to charge different application fees, different amounts to different applicants, and they must provide the applicant with a disclosure for the anticipated or actual expenses to process the application, and also provide a receipt for any application fee paid. Again, landlords, if there's any kind of amount left over after processing that application, you are required to make good faith efforts to return any amounts to the applicants. Now, when processing an application, what type of rental or credit history can be considered? Well, landlords can only take the past 7 years of rental or credit history into consideration. Anything older than 7 years is not a reason to deny an applicant a possible residence. What about criminal history? Arrest records can never be taken into consideration. You can have 1,000 arrests. None of those can be used to deny you a residence. Convictions, however, are a little bit different. Generally speaking, landlords are not able to use any conviction that is 5 years or older, except methamphetamine-related convictions, convictions that would require a person to register as a sex offender pursuant to Colorado Revised Statute, homicide-related offenses, and stalking. Those convictions, regardless of the age, can be held against an applicant and can be used as the basis to deny somebody a potential residence. So what happens if you apply for a residence and your application is denied? Well, you are entitled, you have a right to a written notice of why your application was denied. It should state the reasons, and landlords shall make good faith efforts to provide this to you within 20 calendar days of the decision to deny your application. Now, what happens if you've applied for a place and the potential landlord isn't following the law? They use credit history that they can't, they use an arrest that they can't, they don't provide you with a written explanation, or they're saying that they're not renting to you based upon the source of your income. Well, as an applicant, you can seek 3 times the amount of the application fee, court costs, and reasonable attorney fees if an attorney is representing you in a potential lawsuit. However, you must give that potential landlord a notice that you intend to file an action at least 7 days before filing the action. And at that point, the potential landlord has the ability to fix whatever procedure was not followed properly in the rental application process. However, if you're applying for a place and somebody says, hey, I'm not renting to you, you have an assault conviction from last year, then if they say, well, you're not allowed to do that, you can't deny me based on this conviction, and you bring a lawsuit to that effect and you lose, if a court determines it is a meritless claim, then you'll be liable for the landlord's court costs and attorney fees in that instance. And again, at the bottom there, those are the statutes which cover the Rental Application Fairness Act. So we've gone through the application process, we've gotten approved, and now it's on to sign the lease. So when you have that lease in front of you, read it. Every line, every sentence, every paragraph. Whether it's 1 page or 49 pages, make sure to read every bit of it. Pay attention to key things in there. What's the length of the lease? Am I on a month-to-month, a year, a 2-year? What's the term of it? What happens at the end of that initial term? So if I'm on a year-long lease and we get to the end of that year, well, does it automatically roll over for a year? If I want to move, what kind of notice do I have to give to my landlord in order to be able to end the lease at that end date? And if my landlord is not choosing to renew, what kind of notice do I have a right to as the tenant? What about potential late fees, storage fees, or any kind of utility fees? How about the upkeep and the maintenance around the property? If it's a single family home, what type of lawn maintenance are you responsible for? Are there any, if it's in a multi-family home, if there are common areas, what are your responsibilities for upkeep and maintenance of any kind of common areas? I would imagine that there shouldn't be too many because those would be the landlord's duty. But just again, it's important and critical to read your lease at the beginning to make sure that you have a grasp on what are the rules as it relates here. Also, is your tenancy an exempt residential agreement? What about with the warranty of habitability? What about appliances which are included in the lease, which would be subject to the warranty of habitability? And any email address for electronic notice delivery there, where if you have an issue regarding habitability, where are you able to send an electronic notice to? So as indicated on the last slide, some leases are what's called an exempt residential agreement. This only applies to single family homes, so not apartments or condominiums. And it is a single family home that is leased by a landlord who owns 5 or fewer single family rental homes. And notice is provided in the lease that the 10-day notice period does not apply to the tenancy. So no oral leases can be exempt. And what this essentially means is that if there is some kind of lease violation, whether a rule violation or non-payment of rent, an exempt residential agreement only allows a tenant 5 days to cure the violation instead of 10 days for non-exempt residential agreements. Also, as you're reviewing your lease, you want to keep an eye out for anything that would be an unenforceable lease provision. For example, you cannot waive your right to the return of your security deposit. You cannot waive your right to the warranty of habitability unless there is a separate agreement supported by consideration, and you have the skills to do so. You cannot waive your right to the covenant of quiet enjoyment, to a 5 or 10-day demand for unpaid rent, or for the court process for eviction cases. Also, now that we've read the lease, we've signed the lease, make sure to get a copy of your lease, not only for your own records, if there's ever a dispute, but you have a right to it. The law requires that your landlord provide you with a copy within 7 days of you signing the lease. Also, if you're any kind of cash or money order payment that you are paying, again, that's another critical thing to look at the lease for. How am I to pay the rent? Is cash accepted? Does it have to be certified funds? Are money orders okay? So if you're paying by a money order, you want to make sure that you get a receipt for that. That way you keep good records of all payments made. So for both the security deposit and for any rent payments, if you pay your rent or security deposit with cash or a money order and you request a receipt, your landlord has to give you a receipt. If you pay in person, they have to provide you with that receipt on the spot. If you pay by mail and request such a receipt, they have 7 days to provide you with a receipt for the payment. Now that the lease is signed, we're about to move in. Let's say the truck's out front with the boxes in it, but before you start unloading the boxes in and making that new house your new home, take the time to document it. Go through and take pictures. These pictures, they may not seem important on day one, but they'll be important at the end of it. They document the condition of the residence at the beginning of the tenancy. Whether that's damaged or undamaged, document everything. Because at the end of your tenancy, if you're disputing on whether or not something was damaged, you want to be able to show, hey, that hole in the wall, that was there in 2021. Here's the picture of it. So again, this documentation is crucial for security deposit disputes. If your landlord is amenable to it, I can appreciate the fact that over the last year and a half, there have not been a lot of walkthroughs being conducted. But if you are able to do a walkthrough, I think that would be a very good idea for both landlords and tenants. You can identify pre-existing damage, and you both enter into the contract with the same understanding of the condition of the residence. Be critical, but not unreasonable. All right, you're paying for this residence. You are entering into a contract to pay for this residence. You saying my window's broken, the faucets do not work, there is a drip, that's not being unreasonable. That's you pointing out pre-existing potential damage that could get worse over time. For example, if you fail to report a leaky faucet and that gets out of control, that can cause damage throughout an apartment building, which you may be then responsible for. So you're paying the residents, you're not being a bother by pointing out any kind of existing damage, and it may help you and your landlord get on the same page at the beginning of any kind of tenancy. Again, remember, this is a business relationship. No matter how, even if you had a personal connection to your landlord before you moved in, before you signed that lease, when you sign that lease, that's somebody you're in business with, no matter what any prior relationship was. And I think it's beneficial for both parties in a business relationship to have the same understanding of the conditions of the home before the tenancy takes off. Also pay attention when reviewing a lease to any kind of rules and regulations. These are going to be additional conditions of your tenancy. And if there's any kind of reference to additional rules, regulations, HOA, make sure to ask for a copy of anything that you would be, any kind of rules that would be imposed on you as a tenant while you're living there. You may receive a copy with your lease. And again, the reason that these can become important is if it is alleged that a rule or regulation is being broken, there is a risk of an eviction. For example, quiet hours in a building, parking procedures, pet procedures, any kind of grievance procedures for neighbor disputes. Those are things that you want to make sure that you're paying attention to as you're reviewing the lease itself. Now, before we get into the warranty of habitability, I want to take a quick break to check on any kind of questions over here. If I've signed up for rental assistance but have not supplied my landlord the CDC paperwork, will signing up protect me? If you are facing an eviction for non-payment of rent specifically, then providing your landlord with the CDC declaration, if you believe you are a covered person, would trigger that protections of the moratorium. And then the follow-up question is, can I file the CDC order with the court for free if my landlord already went to court and got a writ, but I have not been served yet. Court date was today. Filing for free, you would have to fill out the filing fee waiver information. And so long as you would qualify, you would be able to file without cost, but you would have to file a motion to waive filing fees to be able to do so. All right, and let's move on to the warranty of habitability. This may be I could spend an entire evening on this subject. I was just checking the time here to make sure that we're not gonna run out of time for questions at the end here. But essentially what it is the promise that your residence is fit for human living. There are a list of things that by law must be present in your residence or not present. That list is also in the packet online that was referred to at the beginning. We'll review that list here in just a second. Now, if you are facing an issue regarding the habitability of your home, you have to put your landlord on notice of the inhabitability of the home. A work order is not that notice. So, previously, you could only do this in writing to your landlord. It still has to be in writing, but it can either be a physical writing or it can be an electronic notice. So what makes up an electronic notice? It's noticed by email or some kind of portal, electronic portal or management communication system that is available to both your landlord and you as a tenant. If you send an electronic notice, you must send it to only the email address, phone number, or electronic portal specified by the landlord in the rental agreement. Going back to why it's so critical to make sure that you're reading each and every detail of your lease. Well, what if it doesn't say, so hold on, I'm jumping ahead here, sorry. So if the lease says, hey, you have to send it to this email address, and you send a text message to a phone number, that's not going to be sufficient electronic notice because your lease says, here is the email address that you have to send any electronic notice. So what if it doesn't say anything? What if the lease is silent? What if you have a 5-year lease and when you signed the lease, you didn't have a right to send electronic notice? Well, if your lease is not specific, then you have the ability to communicate with the landlord in a manner that the landlord has previously used to communicate with you. What does that mean? Practice controls. If your landlord's previously texted you, then you can text. If your landlord's previously emailed you, then you can email, and that would be the email address that you could send an electronic notice to. That would be the phone number that you can send an electronic notice to. Also, make sure to keep sufficient proof of delivery of the electronic notice. If that's an email, print out a copy of the sent email. Try to send it with some kind of read receipt or proof of delivery. All right, kind of, that your email was delivered. Now, what are the conditions that make up the warranty of habitability? There has to be sufficient waterproofing and weather protection of your roof, walls, doors, and windows. The plumbing and gas must be in good working order. Bear with me here. There we go. Running water, reasonable amounts of hot water, proper fixtures and connections to the sewage disposal system. Functioning heating in good working order and in compliance with the law. Electrical lighting and wiring and equipment in good working order and in compliance with the law. Common areas under control of the landlord kept reasonably clean. This is a very tough one to really make a warranty of habitability claim regarding. Just because a lobby area may be dirty, that doesn't really qualify. It has to rise to such a level that essentially you can't get to your residence anymore. Right? Landlords also have to have an appropriate extermination in response to any infestation. We'll talk more specifically about bed bugs because there are specific rules to bed bugs. Let's chat about them now. So as a tenant, if you know or reasonably suspect that your dwelling unit has bed bugs, then you have to promptly notify your landlord of that knowledge or belief. Landlords, if you get that notice from your tenant within 96 hours, so within 4 days of receiving that notice, you've got to do the following. You've got to obtain an inspection by a qualified inspector, and you have to provide a tenant with 48 hours of notice of any kind of inspector or pest control agent's intent to enter the dwelling for that inspection. Landlords may also enter the dwelling unit or any contiguous unit for the purpose of an inspection. So if you're on the second floor of an apartment building, your landlord can inspect units on the first floor, the third floor, and your neighbors. If the inspection confirms that there are bed bugs, then landlords are required to inspect all contiguous dwelling units as promptly as is reasonably practical. Landlords are responsible for all of the costs associated with an inspection for and treatment of bed bugs. Now, going back to that cost part about the landlords are responsible for the cost associated with the inspection and treatment. Tenants, you are responsible for making sure that the residence is ready for said treatment. So if you have to buy, Tupperware tubs or something to store things, that's not a cost that will fall to the landlord. That is a cost that you as a tenant would have to take on. So after an inspection is conducted, landlords must provide a tenant with written notice within 2 business days about whether the dwelling unit contains bed bugs. If the inspector determines that there aren't any, then that notice must also inform the tenant that if the tenant's concerns remain, that the tenant may contact the local health department. If the inspector confirms the presence of bed bugs, then the inspector has to provide a report to the landlord within 24 hours. And then not more than 5 business days after the inspection, the landlord shall commence reasonable measures to effectively treat the bed bug presence, including retaining pest control services. So after that inspection, within 5 business days, as a landlord, they have to start treating. Now, as a tenant, you have to comply with all of the reasonable measures to permit the inspection and the treatment. Tenants are responsible for all the costs associated with preparing the dwelling for inspection and treatment. So if you've got to go buy some black trash bags to throw all the clothing in, that cost of the trash bags is the tenant's cost, not the landlord's. If a tenant knowingly and unreasonably fails to comply with the inspection and treatment requirements, they may be liable for the cost of any treatments and contiguous dwelling units if the need for treatment arises from the non-compliance. If you don't allow a landlord to inspect and an infestation gets worse and starts spreading, if it's unreasonable for you to have not allowed them to inspect, then you may be responsible for the cost of inspecting and treating all of the units, and the landlord would no longer be responsible for those costs. Landlords are not allowed to rent a unit that they know or reasonably suspect to contain bed bugs. And if you request it, a landlord is required to tell you whether, to their knowledge, the unit contained bed bugs within the last 8 months and or the last date the unit was inspected for and found to be free of bed bugs. If a landlord does not follow these rules as it relates to bed bugs, they will be responsible for a tenant's actual damages. Landlords are also able to apply for injunctive relief against someone who is refusing to provide reasonable access to the dwelling or failing to comply with reasonable requests for inspections or treatment. If a court, now that injunctive relief is going to happen in court, and if a court finds in favor of a landlord on that issue, they may issue an order which includes granting the landlord access to the dwelling, the right to inspect and treat, and requiring that the tenant comply with specific inspection and treatment measures or assessing the costs and damages related to the tenant's noncompliance. So we're still in the warranty of habitability, and landlords are required to provide an adequate amount of outside receptacles for garbage. What does it look like to violate this? Well, none. If there are no outside receptacles for garbage, that would certainly be a breach. And also, I would say that if you have kind of one trash can for a multi-unit apartment building and it's just not feasible, then that probably also is not an adequate amount of outside receptacles. The floors, the stairways, and the railings must be working. Locks, there must be functioning locks on exterior doors and security devices on any windows that open. There must be compliance with all applicable building, housing, and health codes, which may materially interfere with your life, health, or safety. And then we get to mold. So mold is specifically outlined in the warranty of habitability. It's defined as microscopic organisms or fungi that can grow in damp conditions in the interior of a building. And a residence is uninhabitable due to mold when there is mold that is associated with dampness or there is any other condition causing the residential premises to be damp, which condition, if not remedied, would materially interfere with the health or safety of the tenant. Now, this excludes the presence of mold that is minor and found on surfaces that can accumulate moisture as part of their proper functioning or intended use. Think about, the sink in the bathroom. So after getting out of after getting out of a shower or a tub, all of that kind of steam that's in there, make sure that that airs out so that you're not dealing with mildew that then becomes mold in the bathroom, because that may not be a violation of the warranty of habitability. Appliances are also included in the warranty of habitability. More specifically, refrigerator, range stove, or oven included with the residence for the use of the tenant pursuant to the lease or any other agreement between the landlord and the tenant. Now, the warranty of habitability only applies to the appliances specifically listed in a written agreement or otherwise actually provided by your landlord at the beginning of your tenancy. Certain items, such as, let's say there's a window air conditioning unit, if it is not, it may, it's my opinion that at this point, I don't believe that a window air conditioner unit, if it were to, break during a tenancy, would violate the warranty of habitability. But again, each case and issue is different. So I'm not saying that as a blanket statement, but just as an example of an appliance that is not specifically listed in the statute, but may be provided by a landlord to a tenant. So if you're making a demand based upon an appliance and the landlord replaces the appliance, then there's a presumption that the replacement appliance is not installed in retaliation so long as it has substantially the same features as the original appliance. I like to think about this in the context of refrigerators, and you can essentially get a refrigerator with a TV in it now. So if you have the top of the line smart refrigerator, tells you the weather, sings you a song, and makes you a smoothie in the morning, and it breaks, and your landlord just replaces it with a regular refrigerator, that's not retaliation. Now, if your landlord replaces that refrigerator with a Coleman cooler, that is retaliation. It does not have the same features as the original appliance. If you go from a refrigerator with freezer to kind of one of those almost the small mini fridges, I would wager that that's also not having substantially the same features, as it would lack a freezer at that point. One of the kind of broader categories under the warranty of habitability, which it's not specifically defined, but it is a condition that materially interferes with a tenant's life, health, or safety. This is somewhat subjective because it's based upon the tenant's individual. It can be based upon a tenant's individual characteristics or medical issues that would a condition would then interfere with the health or safety. And it also significantly alters a landlord's response. So we'll get into what those responses are, but when does a landlord breach that warranty of habitability? Because step one in this kind of area is that we've identified that there's an issue in the residence, which is going to make the residence uninhabitable. But just because your residence is uninhabitable, it does not necessarily mean that your landlord has violated or breached the warranty of habitability. So the first step, again, the residence has to be uninhabitable as described by statute, that list of conditions, or it is in a condition that materially interferes with a tenant's life, health, or safety. And the landlord has received reasonably complete electronic or written notice of the condition and failed to commence remedial action by employing reasonable efforts within the required time. So the residence has to be uninhabitable. The landlord has to have received a reasonably complete notice of this uninhabitability, and the landlord also has to have failed to commence remedial actions by employing reasonable efforts within the required amount of time. What is that required amount of time? There are three different timelines to think about. One is if it is a condition that materially interferes with life, health, or safety, a condition that is uninhabitable by statute, and then mold. So if it is a condition, if it's a life, health, or safety condition, a landlord has 24 hours to commence remedial actions. Now, what about a statutory condition? 96 hours to commence remedial action, like a broken window, door locks broken, no hot water. But that 96 hours only applies if the tenant has included permission for the landlord or landlord's authorized agent to enter the premises. Now, on this last part, if you are giving your landlord some kind of notice of habitability issue, just include a sentence in there that says, and I give you permission to enter the premises because then they have 90, then you put the clock, you start the clock on them and they have 96 hours to start fixing the problem. Now, what about mold? So mold's a little bit more detailed. Within 4 days after receiving the notice, a landlord is required to install a containment stopping active sources of water to the mold, install a high efficiency particulate air filtration device to reduce mold exposure. And they're also required to then maintain that containment until the following actions are done. That's establish appropriate protections for workers and occupants, eliminate or limit moisture sources and dry all the materials, decontaminate or remove damaged materials as appropriate, evaluate whether the premises has been successfully remediated of mold, and reassemble the premises to control moisture, to control sources of moisture and nutrients to prevent or limit any recurrence of the mold. Now, when you give as a tenant, if you give your landlord notice or demand regarding habitability, you have a right to response. Landlord, you have to provide a written response, not a phone call, but a written response. And you have to provide a written response within 24 hours of receiving the notice. The response must contain your intention for remedying as a landlord, you have to state what your intention is for remedying the condition, an estimate of when the remediation will start, and an estimate of when the remediation is going to finish. So when am I going to start the work and how long is it going to take to finish the job? What about an alternate residence for a tenant who has an uninhabitable residence? Yes, in some situations. So if the residence is in a condition that materially interferes with the tenant's life, health, or safety, and the tenant makes a request for an alternate residence, then the landlord has to provide a comparable dwelling unit as selected by the landlord at no expense or cost to the tenant, or a hotel room as selected by the landlord at no expense or cost to the tenant. Some other things about an alternate residence. Landlords are not responsible for any other costs that arise after the relocation period. If your residence is uninhabitable and you're put in a hotel and there are additional costs related to the hotel, maybe you have to drive a little bit further to work, those are not costs your landlord's responsible for. Also, as a tenant, you still have to pay your landlord the rent during that time. And again, keep in mind, this only applies to that material interference with life, health, or safety when we're talking about why is the residence uninhabitable. So what, as a tenant, if your landlord breaches the warranty of habitability, what options do you have? So after providing proper notice, and that's key because remember, there's no breach if there's not reasonably complete electronic or written notice provided to the landlord. As a tenant, you can terminate the lease. You can obtain injunctive relief in the county court or district court. You can defend against an eviction for non-payment of rent. You can withhold rent. You can offset rent. Withholding rent. So if you withhold rent based upon a breach of the warranty of habitability, and your landlord takes you to court to try to evict you for non-payment, you're going to have to pay into the court the amount that you withheld to be able to say, the reason that I didn't pay you this money was because my home was uninhabitable. If there is a problem or a defect with the notice that you provided to your landlord regarding the warranty of habitability, then you will not have grounds to withhold rent. I would strongly recommend seeking some kind of legal advice before taking this step of withholding rent, because if it's not taken properly, you will be setting yourself up for an eviction. And also keep in mind that you can bring a lawsuit for breach of warranty of habitability outside of an eviction. You don't have to wait for your landlord to take you to court to make this an issue with the court. You do have the right to file suit prior to an eviction and to seek either injunctive relief or to seek actual damages from the breach of the warranty of habitability. You can also, as I said, you can deduct the cost of repairs from the rent. This is an incredibly specific process. It does not apply to everyone. You cannot deduct for certain issues. Landlords have the ability to also, who you can get to do the repairs is limited. Landlords have the ability to seek out their own estimates. And again, since this is a very specific process, generally speaking, I advise against this. However, if you are considering this, I would strongly suggest that you seek legal advice. If this is not done properly, then it is incredibly problematic for a tenant. If a tenant wrongfully deducts rent, the landlord will get a money judgment in that amount withheld, and the tenant will also likely be evicted for non-payment. If it is a bad faith deduction, meaning that for some reason that the deduction was not taken in good faith, for whatever reason that may be, then a court's going to enter an automatic judgment for eviction and a money judgment against the tenant for 2 times the amount withheld. So again, this is an incredibly specific process. If not done correctly, it will amount in legal ramifications for a tenant. So if you are considering this, please seek legal counsel before doing so. Now, with all this about the warranty of habitability, what are the exceptions to it? So, as I indicated in the beginning when talking about reviewing your leases, there are some exceptions to the warranty of habitability. Now, the exceptions really apply when the person has the skill, okay? So it has to be a written agreement that is separate from the lease. So it can't just be paragraph 18 of your lease. It has to be a separate type of agreement. It has to be signed by both parties, and it has to be supported by adequate consideration. Meaning if you're a tenant, you have to receive something in exchange for giving up this right. Tenants also must have the skill to perform the work. So unless you are a carpenter or an electrician or a plumber or have some kind of specialized expertise, I would, generally speaking, not advise entering into these agreements. Again, if you have questions about one, you're always able to seek legal advice. You can always apply with Colorado Legal Services for possible assistance on a matter. Again, if you're unsure about whether this would apply to you, please seek legal advice. Some other resources here for folks if they're facing some kind of warranty of habitability issue. You can contact the Community Development Office here in the city. You can contact the Department of Health. You can also contact the El Paso County Planning and Community Development Office. You can also contact code enforcement, but code enforcement does not enforce the warranty of habitability. Code enforcement enforces the city code's minimum housing standards. Some issues, and the reason I point that out is that it's not a complete overlap between the two. There are some things that are included in the warranty of habitability, like mold, not included in the city code. There are some things in the city code, like screens on your windows, and I think it's screens on the windows, that are not included in the warranty of habitability. Now you can certainly call both, but one way to kind of think about it, the warranty of habitability applies to court, and code enforcement is for the city code. Before we move into security deposits, I'll check the chat for questions regarding the warranty of habitability.
So Clinton, I don't think we had any specifically about the warranty of habitability, but we did have a question about the previous discussion of, I think it was maybe source of income discrimination. So we have a landlord with a question about multiple applicants and choosing one.
So if I received 4 qualified applications at the same time and chose one over the other 3, can any of the applicants that were not chosen file a lawsuit against me? If so, why can they file a lawsuit? So long as you're not rejecting a person for one of the prohibited reasons. And in this case, it sounds like I received 4 qualified applications and you picked one over the others. So long as you're not using one of the barred reasons, you're not using credit history that's older than 7 years, you're not using an arrest record, you're not using a conviction that's older than 5 years, with one of the exceptions, you're not discriminating based upon race, gender, transgender status, national origin, religion, family status. I don't think that there's grounds for lawsuit. Certainly in this housing market that we're currently in the rental market, I would imagine as a landlord, most landlords are going to be receiving multiple applications for the same property. So long as you're not violating the Rental Application Fairness Act, I don't think there are grounds for a lawsuit, because if you only have 1 unit, you can't rent 1 unit to 4 different applicants. Can I give my landlord CDC paperwork after the judgment to evict, but have not been served yet? Yes. I live in a mobile home and gave CDC paperwork for lot rent, but not my house payment. Does the paperwork cover both, or do I have to give each a copy? I don't know. That's a bit specific. To err on the side of safety, if you are concerned that you are going to be evicted for either your lot rent or your house payment, then it may be beneficial to give both a copy, but that may be a little too fact specific for tonight's presentation. If you would like to follow up and apply online or over the phone with Colorado Legal Services for possible additional advice, I would strongly recommend that. All right, and I know that there were some here. So this was a question from the beginning, and this was regarding the warranty of habitability. I will, Kathy, it's probably a little bit too fact specific for me to answer, but I'll just, let me see here. We've had electricity gone from our bedroom for almost 4 weeks. We paid our rent for last month because we didn't want to get evicted. We submitted the warranty of habitability to our landlord and our HOA last week. They have given us temporary lighting. However, they will not fix the electricity within 96 hours. It will most likely be another month before contractors will complete the work. What options do we have at this point? I'd like to see what their written response. The tough question is, sorry. The short answer is this is a little too specific for me to get into this evening because I would like to see what the written response was, if any. I'd like to review your lease, also any kind of HOA bylaws to really see what your options would be, and also talk a little bit more about the temporary lighting. Now, if the temporary lighting is causing an increase in utility usage, that may be something that you want to approach your landlord about. And this is, I'll go to the next question from the beginning, kind of more related to lease provisions. My lease is through November 30th, 2021. The lease says that I'm assuming landlord cannot show until 45 days prior to the end of the lease. They fired the property management company. They have been pressuring me to clean, organize for picture day. I am in middle of negotiations with their friend who is a realtor. Before I agree to anything, I offered to raise rent for a year extension if a new buyer wants to occupy before my lease is up, a month's rent. I need deposit and rent up front. So the question is, when an agreement is reached that spells out the possible scenarios, does this constitute an amendment to my current lease and therefore be drawn up via legal documents? I also see reference to some kind of court case in Texas. If this property is in Texas, then I can't offer any suggestions or opinions because I'm not licensed in the state of Texas and I have no idea what Texas law is regarding evictions. Again, I'd have to read through your lease to really see kind of what, if there are any possible amendments to the current lease. So if you do want us to take a further look at that, Stacy, I would recommend that you apply for CLS services. All right, moving back and seeing no other questions, I'll jump right back into security deposits. The first thing here is, when can your landlord keep your security deposit? And we briefly touched on a security deposit issue in that last question. Landlord, security deposits aren't your money. You need to keep them in a separate account, and you've got to make sure that you're not commingling funds. It's not your money. It's money that the tenant has, that you're placing in an account to ensure that your tenant fulfills their contractual obligations pursuant to the lease. It is not your money. If, however, as a tenant, when can your landlord keep your deposit? So we've, at this stage, we've gone through the entire tenancy, and now we're about to move out. So what's going on with the security deposit? Well, if there's damage beyond normal wear and tear, then the amount to repair can be kept. Non-payment of any rent, if there's abandonment of the residence, and typically your lease is going to define what abandonment means. So that's just yet another reason to make sure that you're reading each and every lease clause in your lease. Any non-payment of utilities, repair work, or cleaning work contracted for by you as the tenant that was not paid for. So what is normal wear and tear? That's the usual deterioration which occurs when living in a residence. What is not normal wear and tear? Careless or intentional destruction of property. Carpets are going to have wear from walking in kind of the same path. Walls don't develop holes. So if you punch a hole in the wall, that's not normal wear and tear. If the carpet is worn down because you walk through the same hallway, that is normal wear and tear. So again, if we've hit this point and we're concerned about security deposits, what steps should you take as a tenant? First of all, clean the residence. Go out, clean the oven cleaners, make sure you're getting all of it. Make sure to clean the appliances too. Do another walkthrough if you're able to. Take more pictures. Also, go back and look at that set of pictures that you took at the beginning and take the same pictures at the end. All right. That way you have it bookended. You have, this is what the place looked like when I moved in. Here's what it looked like when I moved out. As you can see, I took the same pictures, so we get a clear view of the lack of damage, or that this is just simply normal wear and tear. Also, you need to return the keys to your landlord, and you have to provide them with a forwarding address. So if you don't, this next question of how long does my landlord have to return my deposit and or statement of deductions? If you don't provide your landlord with a forwarding address, they don't have to. Now, by law, they have 30 days to provide you with that deposit and or a statement of the deductions, but it can be extended up to 60 days if it is written in your lease that way. So just yet again, read the lease, read every line. Now, what should you do if your landlord does not return your security deposit? Well, you send them a demand letter. The best practice is sending it via certified mail because then you get a signature. But if you're sending it to a PO box, then just some kind of tracking to show that it was delivered would be sufficient, in my opinion. You're also going to want to keep a copy of that letter. Here's just kind of a sample letter stating that, kind of two types here. The one here over here, this is for where there was a lot of deductions. The one over here is saying that I've never received anything. Okay. Your landlord may only refund part of your deposit. So beware of any kind of restrictive endorsement, which states, acceptance of this resolves any and all disputes related to the security deposit. Now, if you receive only part of your deposit back, you also are supposed to receive a detailed accounting statement just listing the reasons that you are not receiving your full deposit back. If you don't receive that, your landlord is potentially breaching the Security Deposit Act. So let's say you've sent that, you've either received nothing or you've received an accounting statement and you disagree with it. So you send your former landlord a demand letter saying, hey, send me my full security deposit back. If you don't within 7 days, I will pursue further legal action. You can then initiate a small claims action if the amount is under $7,500. With security deposits, you can also seek treble damages, meaning 3 times the amount that was wrongfully withheld. All right, now you can only seek those treble damages if you file a lawsuit within 1 year of the wrongful withholding, and the court finds that that wrongful withholding was also a willful withholding. What does a willful withholding mean? Well, the case law would say that if the landlord deliberately fails to return the security deposit during the additional 7-day period, that's that demand letter, the retention is logically willful under this section. All right, so now that we're at the end, that's kind of the security deposit portion of things where if you've gone through the entire lease, and what are we looking at then and any potential sources of conflict, and that would be security deposit disputes. Now, what about if we're moving out, but it's not at the end of the lease term, and we want to move out we want to essentially terminate the contract early? Is that possible? Sometimes it's possible by the language of the lease. Some leases permit it with if you pay an extra month rent. Again, review your lease to see where and if that is possible. A breach of the warranty of habitability is also grounds to terminate the lease early. There is also early lease termination available for victims of domestic violence, domestic abuse, stalking, and/or unlawful sexual behavior. If there are military orders, that also provides the ability for an early lease termination. And also acts of God, so long as it was not caused by your negligence. For example, if your house burns down, that terminates your lease. If your house burns down because you set it on fire, you're going to be responsible for the remaining rent payments and probably a lot more. But if the act of God was not caused by your negligence, then that would also terminate the lease early. You're able to terminate a lease early under two ways under the warranty of habitability. The first way is if your landlord doesn't respond. The second way is if there are multiple breaches of the warranty of habitability. So if the same condition of the residence renders the home uninhabitable 2 times within a 6-month period, and that condition is not appliance related, then tenants have the ability to provide their landlord with a 14-day notice in writing saying, this is the second violation of the warranty of habitability. It's the same condition. I'm terminating the lease in 14 days. Moving on now, before we move into the Mobile Home Park Act, I'm going to check the chat for questions. I just received a little bit of clarification that was not a case in Texas. So again, with the fact-specific nature of this question, I would suggest that you apply for services or seek further legal advice, because I am not in a position to provide that in-depth analysis this evening. Moving to the Mobile Home Park Act. These are additional rights for tenants in mobile home parks who own their homes. If you are renting your home, in a park, or it's a rent-to-own situation and it's not titled over to you yet, then these additional rights do not apply to you. Also, these are rights for tenants in mobile home parks, which have a specific definition. So if you're just kind of on a few acres of someone's property and it's just kind of your mobile home there, then these additional rights likely do not apply to you because it is not a mobile home park. So tenants and homeowners in mobile home parks have a right to a written lease or rental agreement. The termination of the tenancy must be for cause, meaning they have to have a reason, whereas a notice to quit does not need any reason at all. And so what does cause for termination mean? Home is not in compliance with local ordinances and state laws and regulations relating to mobile homes and home lots, improper installation type issues, not following the park's written rules and regulations, the park is condemned or the park changes use, knowing false or misleading statements on a tenancy application, your conduct, your guest conduct, your friend conduct unreasonably endangers the life of a person in the park. That conduct damages or destroys the property of a person in the park in a willful, wanton, or malicious manner. That conduct constitutes a felony offense or was the basis for an action that declared the home a Class 1 public nuisance. A Class 1 public nuisance doesn't mean that you're annoying the park. There is a legal definition to that. Generally speaking, those are things like brothels, betting parlors, paraphernalia shops. Those can all be declared Class 1 public nuisances. So I referred that a park can terminate a tenancy for a homeowner for a violation of the rules, but when can the park change its own rules and regulations? If you give them permission, those rules will go into effect immediately. If you don't give them your permission, those rules will go into effect 60 days later. Now, there have been some updates to the Mobile Home Park Act, and just to kind of briefly touch on those, with a demand for compliance, homeowners now have the right to a 90-day cure period, meaning 90 days to fix the issue. If there is a notice to quit, then because notice to quit for a repeat violation, or a notice to quit because something was not cured within the demand period, then it's a 90-day notice to quit to either move or sell the home. Security deposits cannot be greater than 1 month of rent. There's additional homeowner privacy by requiring management to provide notice for any entry. And there are additional changes to the act that we really just don't have the time to get into tonight. There's also, this is as of last year, the Mobile Home Dispute Resolution Act. And I may go through this a little bit quickly to make sure that we get to kind of open it up for questions at the end here. So this is a alternative dispute resolution method. This isn't in court. So any party, park management, or tenant may file a complaint with the Division of Housing. Once that complaint's received, the Division of Housing is going to investigate it. If it's appropriate, they'll facilitate negotiations between the parties. If they're unable to come to an agreement, then the division is going to make a written determination of whether there was a violation, and that determination must state the basis for that determination, the violation, the necessary action or actions to cure it, the time to cure it, the penalties for not taking the necessary actions to cure it, and the process for contesting the determination and penalties by means of an administrative hearing. If the determination is that there is not a violation, the written determination must include the basis for the decision and the process for contesting the determination. Party found in violation has 7 days to come in to comply with a notice of violation. And if the party fails to do what is necessary, the division has the authority to impose financial penalties for each day that the party fails to come into compliance with that division of housing's order. They can also issue a cease and desist order to stop an unlawful practice and can order a party to take actions such as refunding monies paid, filing documents that correct the violation, and or taking action to correct the violation. Any decision can be appealed by requesting a hearing before an administrative law judge, and then that judge is going to hear testimony and receive evidence to determine if that prior decision is supported by what's called a preponderance of the evidence, meaning it's more likely than not. The judge is then going to enter an appropriate order within 30 days after the hearing and send copies of the order to the parties. So moving on from the Mobile Home Parks Act, now we're going to get into the court process for eviction cases themselves, which is the Forcible Entry and Detainer Act. Again, this is a procedure for evictions in Colorado. Got to use the court process. Landlords, you cannot use self-help. The Forcible Entry and Detainer Act lists the specific reasons that a landlord can initiate an eviction action. And again, that information's in that packet that's posted online. The first step, really the first step in any eviction case, is going to be receiving a notice to quit or a demand for compliance. There's no specific language or state form required for a notice to quit. It has to describe the property. It has to state the date of determination of tenancy. It has to be signed by the landlord and must be served by statutory deadlines. So on a notice to quit, for most types of tenancies, there doesn't have to be any kind of reason for the termination. This does not apply to low-income housing tax credit properties, mobile homeowners in a mobile home park, or public housing. But as far as a notice to quit form, it does not require a specific state form. It does not have to be notarized. It could be written on a Post-it note, so long as it meets the legal requirements. If you are a landlord on this, please do not use Post-it notes. I don't think that is good practice. Now, once the time on a notice or demand has expired, the next step in a forcible entry and detainer process is going to be being served with that summons and complaint. Now, the service has to be either personal service, which is when the document's handed to you directly, or service by posting. One difference here is if it's service by posting, landlords are only able to receive a judgment for possession and not able to pursue any kind of monetary judgment. However, as a tenant, if you were served by posting and you appear on your return date or file an answer, you then waive personal service, meaning your landlord is then able to pursue a judgment for possession and a judgment for damages, as are you as the tenant as well if you file a counterclaim. So where does a counterclaim go? Well, that goes in the answer. Now, your answer is your legal defenses in response to the complaint. And there are a variety of different defenses. Don't really have the time to go through what all of those are. But if you have questions on, is this a defense? Please apply for services with CLS. Now, one new defense regarding the warranty of habitability. So, as I indicated previously, the warranty of habitability is a defense against non-payment of rent in some cases. Also, if a landlord retaliates against a tenant for making a good faith complaint to the landlord or a government agency regarding the warranty of habitability, the tenant can assert the breach of the warranty of habitability as a defense to a non-monetary eviction. A notice to quit, a rule violation, something where that's just kind of a pretext of, hey, they're saying this is my landlord's saying this is the reason, but in actuality, they're really doing this because I made a complaint about some uninhabitable conditions in my home. Make sure to appear at your return date, and I should have put appear in quotation marks. Currently, El Paso County has non-appearance return dates. So what do you have to do by that time? Well, you have to file an answer or contact your landlord or landlord's attorney to reach some kind of settlement. So when you're thinking, what do I have to do for that return date on the summons? You've either got to get an answer filed, or you've got to work out some kind of agreement with your landlord. Now, if you do neither of those things, then the court issues what's called a default judgment. A default judgment is a default eviction, and then kind of discussed earlier when talking about the new laws, the court may then issue the writ of restitution 48 hours after the entry of a judgment for possession. However, law enforcement cannot do anything with that writ until 10 days after the judgment for possession has entered. One of the last areas to touch on tonight, very briefly, is going to be fair housing. I say very briefly because we could talk about fair housing for an entire weekend and still not cover it all. But just very basically, the nuts and bolts here, fair housing prohibits discrimination based on race, color, disability, sex, sexual orientation, including transgender status, national origin, national or ancestry, religion, creed, marital status, and or familial status. There's also new legislation pending to add gender identity and gender expression as protected classes. There are exceptions to the Fair Housing Act. Those exceptions are for owner-occupied buildings with 4 units or less, single-family housing sold or rented without the use of a broker, housing operated by organizations and private clubs that limit occupancy to members. Also, I wanted to point out a distinction here between service animals and emotional support animals. Service animals by law are only able to be a dog or a miniature horse. They are covered by the Americans with Disabilities Act, and they are trained to do work or perform tasks. They are not a pet. They are the same thing as a nebulizer. They are an oxygen tank. They are a medical device. Now that's service animals. Emotional support animals are not covered by the Americans with Disabilities Act. However, they do trigger fair housing protections because the denial of a tenant's emotional support animals may be discriminating against a tenant based upon their disability. So if you find yourself in this position, then what you may want to look at is making a reasonable accommodation request. What is a reasonable accommodation? Well, first of all, it's a discrimination to refuse to make reasonable accommodations necessary to afford a person with a disability the equal opportunity to use and enjoy the residence. There's no magic language to make the request. However, it must be in writing, and it must state what the accommodation is that you are requesting. If you have mobility issues and you need assistance in the shower, then you'd state, please install I'm requesting a reasonable accommodation of a grab bar in the shower. Let's say there's some kind of, you have, again, on mobility issues, and they don't have assigned parking. You can say, I'm requesting a reasonable accommodation to have this assigned parking space so I don't collapse in the middle of the parking lot. Also, this is also where emotional support animals would come into play, because you'd be requesting a reasonable accommodation made to a no pets policy or a pet deposit to allow you to have your emotional support animals so that you're able to receive an equal opportunity to use and enjoy the residence. There's also a sample letter that's in that packet online as well. And again, here's just kind of a sample letter. There's no real magical language here, just that you have to state what it is what the reasonable accommodation is that you are requesting. All right, I will open and you have my contact information here. More than welcome to contact me with questions. I will tell you that my response is typically going to be, okay, you're going to have to apply for services. But just to give you with a starting point, if you want to reach out to me, I can put you in touch with somebody who may be able to take an application over the phone. So let me pull up the chat here to see if there are any questions, see what questions we have not covered throughout the presentation.
Clinton, I'm not seeing any new ones now, but definitely want to encourage folks to ask them. I am going to, I may need to give the call-in participants the permission to unmute themselves. So I'm going to do that now. So if you're waiting online or on the phone and you'd like to present, I think that I'm giving you permission to unmute yourself and ask a question. Thanks for everyone's patience with the.
Yeah, I think for those of you on the phone to unmute, I believe it's *6. If you have a question for Clinton.
I think I saw someone unmuted. Did you have a question?
I have a question of what is the procedure for transferring a case from county court to district court? In a lot of instances, that's not going to be possible. If it depends, if the case is initially filed in county court and there are counterclaims or cross claims that may take a case beyond the jurisdictional limit of county court, then it can be removed to district court. If somebody is asserting a property interest in a home, or if somebody's asserting an interest in real property, then that would have to be determined by district court. But beyond those two kind of more specific situations, it probably, in most situations, it's not going to be able to be transferred from county court to district court.
Clinton, if I may ask a question that's fairly generic and something that a question I've gotten from a few folks who've called into the Community Development Division. If a person has applied for emergency rental assistance program funds several weeks, maybe even months before the moratorium lifted, and then applied again, and they're served an eviction notice of eviction for non-payment because those grant funds have not been paid to the landlord from the state in a timely manner. How likely is it to, what's the procedure once they go to court and they have this record of applying for funds?
That's a tough situation. And again, this is all case by case. One thing to keep in mind is that if you're applying for rental assistance, landlords do not have to cooperate with the program. But if your landlord has cooperated with the program and has agreed, then what I would recommend is to contact someone at DOLA, someone at the rental assistance, to try to find something in writing from your landlord saying, hey, we're going to agree to accept this payment, and them saying we're going to pay it, because that could operate as a waiver because they've accepted some kind of representation of payment. So it's really tough. It's a case by case situation. To foreshadow this fall's new housing law, that type of issue may not exist come October 1, 2021. Because as of October 1st, 2021, if you are facing again, this is not the current law. This becomes law October 1st. Beginning October 1st, if you have received a demand for payment, you have the ability to cure that payment or to cure that non-payment up until a judgment for possession is entered. So to kind of with the rental assistance funds, I think keeping clear and open communication with your landlord and providing them any and all kind of communication that you're getting from the rental assistance folks, just to show them, hey, I've applied, I've been approved, here's the timelines, just to show them that, just to kind of, as a good faith, as a showing of good faith. That may not be necessary come October 1, but again, tune back in for the fall presentation where we'll be covering all of the new laws that are going into effect. But as far as kind of what to do in that situation where your landlord's taking you to court because the rental assistance has not come through, contact the rental assistance provider to see if they can expedite the payment. See if there's anything that the landlord agreed to or signed off. Your landlord signed on to saying we're going to accept this payment, because that may operate as a legal defense in the case. Also, I would strongly suggest that you contact Colorado Legal Services for potential assistance on that matter as well.
Thank you, Clinton.
Thank you. Any other questions? We want to make sure to give folks an opportunity. While you're thinking about or typing a question, I'll just remind everyone that we will be providing the slides and the video for this presentation online and to folks who register. And I'm going to go ahead and put again in the chat the links to register or subscribe to the Community Development Division's newsletter. And we don't have any more questions. Thank you so much, Clinton, and all of our presenters. Let me go ahead and put up our thank you slide. And there's me too, if you're watching. Really want to thank everyone for coming, especially thank you to all of our partners, Deb Hamilton, Britt Kwan, Katrina Brown, Clinton Albert, and Catherine Duarte for keeping track of all the questions. We also wanted to let folks know, I just found out, and this may actually be Clinton who is going to be giving, there's another workshop coming up in a couple of days that's on COVID-19 eviction prevention workshop. And I'm going to post that in the chat as well as another opportunity for anyone to share with folks. We really appreciate you being here. I also want to draw special attention to the Emergency Rental Assistance Program, which has already been talked about, but I want to make sure everyone has a link to, so I'm posting that in the chat as well. It does take a while once you apply to have that whole thing processed, but funds remain available for renters in the state of Colorado and El Paso County and Colorado Springs who have been unable to pay their rent as a result of COVID-19 and the pandemic. So we do encourage people to be persistent and to apply for those funds if needed. I think that's about it. I just want to express again my gratitude to all of our presenters for being part of this. And one last thing, Britt, correct me if I'm wrong, but I believe the feedback survey for these is still live and available. We would love to hear your feedback about these workshops. They are ongoing. So there's a link here for the survey that I just posted in the chat. You can also contact us at some of those other links to let us know what you think. We'd like to continue to improve these. And the Community Development Division, in partnership, we are going to be hosting one more that we have on our current schedule, which I thought was right in front of me. It is November 9th from 6 to 8 p.m. And we will continue. We've seen a lot of other organizations that are doing similar workshops. We will continue to promote those with our newsletter as well from the Community Development Division. And unless there are other questions, I think that's it. And we are ready to sign off. Thank you again, and stay in touch, and good luck with any issues you're all dealing with. So have a good night.